Welcome back to the PI Show, viewers. We're now at that time of the show where we've got Viv's mailbag, brought to you by Kathy.
Good evening,
How are you,
Tony.
Kathy?
Hi, Harry. How
Kathy,
are you?
welcome.
Good evening, viewers, and welcome back to the mailbag. Thank you again for writing in your questions. But I have to say, the medical negligence stories that you have presented tonight is very, very interesting, and not to mention a much heavily debated topic in the media. So, viewers, I hope
It's a very, very complicated area of law,
It
which
is.
Harry would attest to, but, you know, it's one of those areas where you've got to get advice and get things checked out and thoroughly investigated. Isn't that right, Harry?
That is right.
That's
Tony.
right.
We got time for Kathy's mailbag.
Absolutely. So
questions.
yes, please keep writing in, especially if you've got any questions with respect to medical negligence. But moving on, we've got Graham Misson as our first question tonight, and he writes, I am a courier driver, the sole income earner for a small company owned by myself and my wife. I was delivering a parcel to a private address and a note on the front door read, please come around the back. As I did this, I slipped on the grass and broke my wrist. I've put in a work cover claim. However, they do not cover the first 10 days of work nor the lost income for the company whilst I cannot work. Do I have grounds to sue the homeowner for this lost income? Harry, can you please answer Graham's question? I mean, obviously it's pertaining to work cover, but what are his rights?
Look, Graham's in a very difficult situation because it happened in the course of employment. I assume from the question he was employed as a wage earner by the company owned by himself and his wife. So work cover will pay weekly payments for him up until 2.5 years, if he's off work for 2.5 years.
And provided he's maintaining certificates of capacity, Harry, is
Certificates
that correct?
of incapacity, and also they'll pay all the medical expenses. So he's got what's called statutory benefits.
His concern, Harry, is the
But-
earlier period where the employer's got to pay, which is him, effectively.
The company, there's no way around that. That's in the legislation, so there's no easy answer to that. And he's in an awkward situation because he could sue the occupier, that is the householder, and you'd hope they'd have insurance, but he's got to get a serious injury, Tony. And a broken wrist may not satisfy.
That's true.
Not satisfy serious injury if it heals. If there's ongoing problems, and he can't use his wrist on a sort of fairly a long-term basis, then he'd have a serious injury.
Well, Harry, the risk can be quite notorious because there's cartilage.
Healing and depends on
Cartilage
age.
could degenerate or deteriorate over time, so you don't know.
So if he's got
wait
a
and
serious
see.
injury, then he could sue the
Homeowner.
However, he's got to demonstrate there was negligence in the maintenance of the grass or the yard or wherever he fell. So
Might have been a pothole, who
So it
knows?
sounds like a little bit of a difficult claim, but obviously consult your doctor and seek legal advice on that, Graham. Going on to the next question, to the PI show, I want to know why it is that the insurance companies make up the percentage impairments and not the GPs. Tony, this one is for Roy. Could you please answer his question?
Got a brother called Roy, but I'm sure it's not him. It's not the insurance companies that make up the percentage impairments, Roy. It's, in fact, the legislation sets out a process. The process is that they've got to send you to an independent medical examiner who is supposed to be qualified and specialised in impairment assessments. They will give you an impairment assessment and that's it. And if you're not happy with that, you've got a right to go to a medical panel, Harry.
yeah, which is three doctors who can assess the
process,
percentage impairment.
That's exactly right. And the process in doing this is not set out by the insurance company, it's set out by the legislation, which is a parliament. That's the answer, the short answer.
Roy, there you go. We've just answered your question for you, short and sweet. Moving on, Emma has written to us. I have a friend who recently underwent an abortion. She is in her early 20s and is studying at university. She was under a lot of pressure from her boyfriend to have the procedure and was very undecided about what to do. Early on, she signed a form consenting to the procedure, but was forced to do this by her boyfriend. Just before she had the procedure done, she was crying and stated that she did not want to proceed with the abortion. This is the last thing she recalls before waking up and the abortion having been performed. My query is regarding the nature of consent and whether you can withdraw it after you have signed the form. Tony, Emma's query is quite complex. I mean,
I think
it's
you need
a
to
very
see a lawyer in
unfortunate
this one because you need
case.
to get the facts very, very accurately, because I don't think that signing a consent means that you cannot withdraw the consent. but the facts of a case are going to be pretty critical. And as a doctor, I would not be carrying out an abortion with this set of facts, Harry. It's very worrying and disturbing that she's crying and carrying on and saying, I don't want to have an abortion, and she's still...
Depends look, I agree with you. It depends who she's communicated that to and in what language and whether it's clear that she's in effect withdrawn her consent.
Well, Harry, she's really carrying on, so it's a bit of a worry. I wouldn't have done it.
I mean, she might be in stress and strain, but she's got to, I think, communicate pretty clearly to...
But Harry,
well, she said, according to this, she says before she was anaesthetised, she says, I do not want to have the abortion. I think it's pretty
Depends
clear.
on who she told that to.
Yeah.
But
and whether it was properly communicated to Tony, because someone might say, well, look, she never said those words.
Yep. Well,
Now,
the facts are going to be pretty critical.
Yeah,
So,
and depends on witnesses, what was written down, what was noted, and the time lapse between signing the form and having
the procedure.
having the procedure.
But what do you think about the boyfriend? I mean, if he forced her to sign the consent, that's another legal issue there, isn't it?
I wouldn't sue
Yeah,
him.
there's
No, it's not about suing him, but I mean, isn't there something that gives rise to the fact that it was? I mean, she signed under forced duress.
No, I would have been trying to get the boyfriend on side to give a statement to say that she withdrew her consent.
depends where he was, but Tony, what's the injury or damage or loss?
Psychological, Harry. Severe.
Severe psychological.
More than 10% under the Wrongs Act. I think you'd get over the line. Yeah.
And if she was very distressed about that, I mean...
Yeah, it's got to be long-term psychological.
I mean, it raises all sorts of issues, anti-abortion, this, that, whatever. Look, I'm not
But you've got to have, in effect, an injury, if you like, to her.
Severe psych, Harry.
Yeah.
I would say that she would have that from this.
Yeah.
We don't have a lot of time, so
We
we've got
don't,
one more.
but what we would like is for viewers to keep writing into us because we absolutely enjoy this part of the show and we want to keep answering your questions. And I think it's also safe to say that there's nothing too big or small that we can answer for you. So please keep writing in and also catch up on earlier segments and shows that we have on www.thepishow.com.
So we're not doing a bus driver case?
No.
No. Okay. Next week.
No, I mean, there's a lot of questions and we can hold that over till next week.
We can't get to all of them all the time, but of course you can write to the website as well and we will always answer.
That's very enjoyable, this part of the show.
And I'm glad to see your little device is still working.
It is. And I'm just making sure that,
Magic.
the personal injury side of law is keeping up with the times that we're moving forward.
It's in the new millennium.
It is.
It's the new millennium.
Thanks, Kathy.
Thank you for having me back again.
And we'll see viewers next week.
Yeah. Keep watching next week.
Good night.
No.